Hello, and welcome to the Manifested e-learning platform. Today, we are going to do a comparative analysis of the State Corporations Act and the Companies Act in Kenya. The subject is Advanced Public Financial Management. We are on topic number 5, Public Sector Investment and Enterprise Management. So the lesson is a comparative analysis of the State Corporation Act and the Companies Act in Kenya. And here in Kenya, the landscape of corporate entities is primarily governed by two key pieces of legislation. That is the State Corporations Act, Chapter 446, and the Companies Act of 2015. And while the Companies Act provides the foundational legal framework for the incorporation and operation of all companies, the State Corporations Act specifically addresses entities that are owned or controlled by the government. So understanding the interplay and the distinctions between these two acts is important for comprehending the legal and regulatory environment for both private and public entities in Kenya. Now, as we do a comparative analysis, our analysis or our comparative analysis will be on the basis of 4 things. One is the purpose and establishment. Number 2, we will do a comparative analysis on governance and oversight. Number 3, we can analyze the regulatory framework and compliance. Then lastly, the application and overlap of the two pieces of legislation. So the first basis of our comparative analysis is purpose and establishment. Purpose and establishment. Purpose and establishment. Now let's first of all consider the State Corporations Act. The State Corporations Act. Now, the Act is specifically designed to provide a legal framework for the establishment, the control, and regulation of state corporations. And these entities are typically created to perform specific functions of strategic, commercial, or service delivery nature on behalf of the government, often with a public interest mandate. So state corporations can be established by a presidential order, can be established by a specific act of parliament, or just by being registered under the Companies Act with the government holding controlling interest. How about the Companies Act? The Companies Act provides a comprehensive legal framework for the incorporation, registration, operation, and winding up of various types of companies, including private limited companies, public limited companies, and companies limited by guarantee. And its primary purpose, the primary purpose of the Companies Act is to facilitate business and commercial activities by providing a legal structure for enterprises focusing on aspects like shareholder rights, corporate governance, commercial viability, and so on. So we've analyzed the purpose of state corporations, the establishment of state corporations and companies, and also the Companies Act. Let's move on to the second basis for comparative analysis, which is governance and oversight. Governance and oversight. Governance and oversight. Now, state corporations are subject to significant government oversight. State corporations are subject to significant government oversight. And the Act provides for ministerial responsibility, allowing the relevant cabinet secretary to give policy directions. It also establishes oversight bodies like the Inspectorate of State Corporations and the State Corporations Advisory Committee, which play roles in monitoring performance, advising the president on establishment and dissolution, and also ensuring adherence to government guidelines. So the composition of the board of state corporations is often influenced by government appointments. So we are analyzing these two acts on the basis of governance and oversight. Now, on the part of the Companies Act or companies registered under the Companies Act are primarily governed by their memorandum and articles of association, now simply just known as the Companies Constitution under the 2015 Act. And it is also governed by the provisions of the Act. That is governance. Companies that are formed under the Companies Act are governed by the company's constitutions, specific constitutions. Do you understand? And oversight, because we have governance and oversight. How about oversight of companies that are formed under the Companies Act? Now, oversight is primarily exercised by the shareholders, the board of directors, and regulatory bodies relevant to their specific industries like the Capital Markets Authority for publicly listed companies, and so on. So the focus of governance under the Companies Act is largely on protecting shareholder interests and ensuring compliance with corporate law. Corporate law. 3, let's analyze companies formed under the Corporations Act and Companies Act on the basis of regulatory framework and compliance. Regulatory framework and compliance. Regulatory framework and compliance. State corporations are subject to a dual layer of regulation. They must comply with the provisions of the State Corporations Act, including directives from the Inspectorate of State Corporations, as well as the Public Finance Management Act, due to their handling of public funds. Due to their handling of public funds, they have to comply with the provisions of the Public Finance Management Act. They are also subject to audit by the Auditor General. On the other hand, companies governed solely by the Companies Act must comply with its requirements regarding incorporation, share capital, filing of returns, conduct of meetings, and winding up. So public companies are subject to more stringent regulations and disclosure requirements compared to private companies. And compliance is primarily monitored by the Registrar of Companies and other regulatory bodies. So that's how the state corporations and companies formed under Companies Act can be analyzed. Regulatory framework. Regulatory framework. Lastly, we have application and overlap. Application and overlap. Now, the State Corporations Act applies specifically to entities defined as state corporations, regardless of whether they are established by a specific act or registered under the Companies Act with government control. You understand? The State Corporations Act, I repeat, applies specifically to entities defined as state corporations, regardless of whether they are established by a specific act or registered under the Companies Act with government control. On the other hand, the Companies Act applies to all incorporated companies under it. However, when a company is majority owned or controlled by the government, it falls under the definition of state corporation. So if a company is formed under the Companies Act, but such company is wholly controlled by the government, then it's defined as a state corporation. And therefore, the provisions of the State Corporations Act will apply to such a company, even though it is formed under the Companies Act. And it becomes subject to the provisions of the State Corporations Act as well. And that creates an area of overlap where a single entity must comply with the requirements of both acts. That's the overlap we are talking about. So the overlap occurs when government entities are registered as companies under the Companies Act, and while they are legally companies, their government ownership brings them under the purview of state corporations, under the purview of state corporations, under the purview of the State Corporations Act. And that can sometimes lead to complexities and potential conflicts, particularly regarding board appointments, management autonomy, financial regulations, and even reporting requirements. Because the governance principles and objectives of the two acts may not always be fully aligned. So the State Corporations Act often imposes stricter controls on greater degree of ministerial direction compared to the general corporation governance principles under the Companies Act, which are geared towards private enterprises and shareholder value. And in Kenya, recent legislative discussions, and we've had proposed reforms such as the potential introduction of specific legal framework for government-owned entities under the Companies Act, which aim to address some of the overlaps and provide clearer guidance or governance structures for commercially oriented entities where the government has conflicting interests. So that is the comparative analysis of the State Corporations Act and the Companies Act in Kenya. And it's important to note that while the Companies Act provides the general framework for companies in Kenya, the State Corporations Act introduces what we may call a specialized regime for government-controlled entities, reflecting their unique nature, their public mandate, and also the need for enhanced public sector oversight and accountability. So the interaction between these two acts, particularly in the case of government-owned companies, highlights the complexities and the governing hybrid entities within the Kenya's legal system. So that's all for today's lesson. Thank you. We'll meet our next session where we continue to cover the topic public sector investment and enterprise management. Bye-bye.